Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome back to another deep dive. Whether you're, commuting right now or just taking a well-deserved break, we are really glad you're here.
Absolutely. And we have a pretty intense one for you today.
Yeah, we really do. Usually when we look at a standard employment dispute over unpaid wages, there's this expectation of, dry procedural bureaucracy.
Right, like doing your taxes or something.
Exactly. You look at a time card, you look at a pay stub, you calculate the difference, and a mediator just points to a spreadsheet and says, there's the error, write the check.
It's usually very binary. We inherently want these disputes to be contained, right?
Yeah.
Be categorized neatly within the bounds of a human resources manual and just settled quietly in some conference room.
But then you step into the world of systemic workplace vulnerabilities, and suddenly that spreadsheet is completely useless.
Yeah, it goes out the window entirely.
The stack of sources we have on the table today starts with a seemingly mundane argument over hourly wages, but it rapidly spirals into a really terrifying story of harassment, retaliation, and a very deliberate corporate shell game.
And we are working entirely from the established legal record here. This is a federal civil action out of the Northern District of Georgia.
Right, so we're not just guessing. We have the second amended complaint filed by the plaintiff, Makita Bryant.
We also have the formal answer and the 24 affirmative defenses submitted by the corporate defendants. That's CNM Defense Group LLC, its chief operating officer, Charles Reedy, and a spin-off entity called Global Security Management Team, LLC.
And crucially, we have the resolution to all of this. We've got two highly detailed, multi-phase jury verdict forms from January 2026.
Plus a final court judgment for attorney's fees dated just a few days ago, actually, on March 19, 2026.
So our mission today is to essentially reconstruct the anatomy of this massive legal reckoning. We are looking at how a federal jury systematically dismantled a company's attempt to hide behind corporate restructuring.
And how the plaintiff's counsel really brilliantly utilized state torts alongside federal civil rights claims to ensure maximum financial accountability. It's really a masterclass in litigation.
It really is. And just to set the stage for you listening, while we are looking at some very serious allegations today, including assault and harassment, we're examining them strictly through the lens of this established legal record.
Right. We're exploring how the plaintiff's claims, the defendant's blanket denials, and the jury's ultimate resounding verdicts all clash in the courtroom.
So let's start right at the foundation of the power dynamic here, because long before we get to the severe allegations of assault, the vulnerability was already baked into the employment contract itself.
It really was. It starts with a very common yet often misunderstood workplace vulnerability, which is employment misclassification.
Right. So Makita Bryant starts working for CNM Defense Group LLC in April 2021 as a security officer.
And the filings detail that she was paid a flat rate of $15 an hour.
Which, okay, $15 an hour. But she was regularly working up to 100 hours a week without a single cent of overtime.
Yeah, that 100-hour figure is that's the linchpin of the initial structural imbalance here.
100 hours a week is wild.
It is. Under the Fair Labor Standards Act, or the FLSA, those 60 hours over the standard 40-hour threshold command time and a half.
Right. Legally, you have to pay that.
Exactly. But the financial incentive for an employer to bypass that through misclassification is massive. I mean, it's not just wage theft. It's a fundamental restructuring of the risk and reward between capital and labor.
Okay, let's unpack this for a second, because they categorized her as an independent contractor, which is, being an independent contractor is supposed to be like owning your own plumbing business, right?
That's the idea. Yeah, you pick the jobs.
Right. You negotiate your own rates, you solicit multiple clients, you set your own hours.
You're a free agent.
But looking at the evidentiary record here, CNM provided Bryant's schedule. They dictated her specific work sites.
They assigned all her shifts.
And they even provided her uniform right down to the tactical vest she was required to wear. It's like renting a car, but the rental agency tells you exactly where to drive it, when to drive it, and forces you to wear their corporate logo while you do it.
That's a great way to put it. You are an employee disguised as a contractor.
You're definitely not a free agent.
No, not at all. And the defense's reliance on the independent contractor label here just ignores decades of FLSA jurisprudence.
Because the courts don't just look at the title on the contract, right?
Exactly. The courts rely on what's called the economic realities test. They don't care what the contract says at the top of the page. They look at the totality of the circumstances to determine if the worker is, economically dependent on the business.
So what kind of things are they looking for in that test?
Well, they ask things like, is the worker's managerial skill a material factor in their opportunity for profit or loss? Does the worker make capital investments in facilities and equipment?
And in this case, she's bringing absolutely zero capital investment to the table.
Nothing.
She's just showing up where she's told, wearing what she's told, for a non-negotiable $15 an hour.
Right. The courts look really heavily at the degree of control the alleged employer retains. When a security firm dictates the work site, the post orders, the uniform, and the exact shift timings, the right to control rests entirely with the firm.
The worker has zero autonomy.
Exactly. So I want you to think about your own workplace or contracts you might have signed. The label a company puts on you doesn't override the legal reality of the control they exert over your daily work.
But I want to push back on the defense's strategy here for a second, though, because I'm looking at their formal answer from February 2025.
The one with all the affirmative defenses.
Yeah, they submitted 24 separate affirmative defenses, just, shotgun pleading at its finest, throwing everything at the wall.
Standard defense tactic, but yeah, it's a lot.
But their ninth defense specifically claims that they compensated the plaintiff in good faith based on a reasonable belief that their method was lawful. They allegedly relied on administrative regulations.
Right, the good faith defense.
How does a legal team claim good faith misclassification when the client is literally buying the tactical vests and mandating the ship's locations? Like, how do they say that with a straight face?
Well, it's a purely defensive maneuver aimed at mitigating damages, specifically liquidated damages under the FLSA.
Explain that a bit more. What are liquidated damages?
So, if an employer violates the FLSA, they're typically on the hook for double the unpaid back wages. That's the liquidated damages component. A huge penalty.
Ouch. Okay.
Right. So the only way out of that double penalty is to prove that the act giving rise to the action was in good faith and that they had reasonable grounds for believing they weren't violating the act.
But just throwing boilerplate good faith defenses at the wall doesn't change the facts on the ground, does it?
No, it doesn't at all. And plaintiffs' attorneys know that proving good faith requires an incredibly high evidentiary burden from the defense.
Like what? What do they have to prove?
You have to show you actively sought legal counsel or Department of Labor guidance before setting up the pay structure, and that you followed that specific advice.
Yeah.
You can't just say, oh, we thought it was fine.
Right. Ignorance isn't an excuse.
Exactly. But tactically, defense counsel files these affirmative defenses early on just to preserve the right to argue them later. Even if the facts heavily suggest the misclassification was a calculated, willful decision to avoid overtime overhead.
Which it certainly seems like it was here. And that calculated misclassification does more than just steal wages, right? It engineers a hyper-dependent, highly vulnerable worker.
That's the really insidious part.
You have someone working grueling, isolated security shifts, entirely dependent on this one company for her livelihood. No union, no HR infrastructure, and no autonomy.
And that profound power imbalance is the exact petri dish where predatory behavior thrives. The economic dependence forces a tolerance for boundary pushing that simply wouldn't exist in an environment where the worker actually had some agency.
Right. So let's look at how those boundaries were shattered here, because it escalates quickly.
Yeah.
January 2022, Reginald Daniels, who is the vice president of operations for CNM, shows up at Bryant's worksite right at the end of her shift.
The VP of operations. That's a huge power dynamic right there.
Huge. And he says he doesn't want to go home and asks if she wants to go to a strip club.
Just completely inappropriate out of the gate.
Right. She declines, so he pivots and asks if she wants to get some food and talk. And the filings make it really clear she felt compelled to agree because he was the VP.
Of course she did.
He controls the schedule. He controls her income. She's working up to 100 hours a week for this guy's company.
He is immediately weaponizing the misclassification we just talked about. He knows she can't easily walk away or risk insubordination.
So they go to an American deli, and then they take their food back to his company car. And inside the isolated space of that company vehicle, the escalation is just terrifying.
And this is all documented in the complaint.
Yes. He asks for a hug. He begins rubbing her back. He actually pulls her shirt out of the back of her pants.
Wow.
She asks him to stop. He doesn't. He asks her when she last got laid and asks her to let him get her off.
So the physical escalation within the enclosed space of a company vehicle that fundamentally alters the liability framework here.
How so?
This isn't just off-duty conduct between coworkers. This is a company executive sitting in a company asset, exerting structural power over a subordinate.
She rejects him.
Yeah.
She tells him she's uncomfortable, but he makes incredibly explicit comments about his own physical arousal.
It's just relentless.
Yeah. When she protests again, he gives this totally non-apology, saying he went too far, unless you wanted to, and then immediately suggests they get a hotel room.
Oh, my God.
She escapes the car, but the threat is established. Now, the defense predictably tried to brush this off, but legally, this establishes a very specific threshold, doesn't it? We aren't just looking at a generic hostile work environment anymore.
No, we're not. We cross a critical line right here into quid pro quo sexual harassment.
Okay, break that down for us.
Well, the filings indicate that Daniels later offered to do favors for her, like paying to fix her car or securing her a promotion.
So tying her livelihood to his demands.
Exactly. When a supervisor conditions tangible employment benefits or the avoidance of adverse employment actions on submission to sexual demands, the company's liability becomes essentially strict.
Meaning they can't easily wiggle out of it.
Right. In a standard hostile work environment claim, a company can sometimes mount what's called a Farragher-Ellerth affirmative defense.
Which is what?
It's basically arguing they had reasonable policies in place to prevent harassment and the employee unreasonably failed to use them. Like, we have an HR hotline and she didn't call it.
But you can't use that defense if the harassment culminates in a tangible employment action, right? Or if the harasser is essentially a proxy for the company.
Precisely. As the VP of operations, Daniels wields enough proxy power that his actions are effectively the company's actions. He is creating an economic hostage situation.
Submit and get your car fixed. Refuse and risk the 100 hours a week keeping you afloat.
It's an impossible situation for an employee.
And Bryant knew exactly how dangerous this was. The filings reveal a deeply personal detail here, and it becomes really central to the case.
Yeah, this part is really striking.
After that January incident, Bryant was terrified. She confided in her aunt about what Daniels had done, and her aunt, recognizing the danger, gives her a small recording device to keep with her.
Like a little cassette recorder.
Yeah. Bryant starts carrying this device hidden inside her tactical vest every single shift.
Which really highlights the complete failure of the corporate reporting structure here.
She doesn't go to HR.
She doesn't go to the COO. She arms herself with a wire because she intuitively understands that in a misclassified, highly exploitative environment, her word will mean absolutely nothing against the VP of operations.
She needs hard, indisputable evidence just to survive the job.
It's a survival tactic.
And she needed it exactly 1 month later, February 2022. Bryant is working a solitary shift in a guard shack at a work site in Forest Park.
Just completely alone on shift.
Right. Daniels shows up. He tells her CNM recently lost the contract for that site, and he wants her to walk through the empty building with him.
He uses a perfectly plausible business pretext to orchestrate complete isolation.
It's chilling. Once inside, Bryant realizes all the security cameras have been removed.
Because they lost the contract.
Right. Daniels walks to the very back of the building, asks her to follow, and immediately demands sex. She refuses, reminds him he is married. His response is to tell her to let him worry about his wife. Then the physical battery begins. He pushes her against the wall. He gropes her breast. He tries to undo her belt. He unzips his pants, exposes himself, and orders her to touch him.
The false imprisonment aspect of this is terrifying, pushing her against the wall in an empty building.
She is absolutely terrified of being raped. She manages to invent an excuse about a truck pulling up outside just to break away and escape.
The premeditation here is staggering.
Right. I mean, I've seen executives take risks, but walking a subordinate into an unmonitored building after explicitly mentioning you lost the contract, that's not a crime of passion or a misread signal. That's a calculated, predatory logistics operation.
It absolutely is.
Here's where it gets really interesting to me, though. Why would someone in Daniel's position be so brazen? He knew she was a lesbian. He had made comments about it. Yet he pursued her relentlessly, acting like there was zero chance of consequence. Does power just completely blind people to consequences?
It can, but legally, it points directly to the plaintiff's strategic decision to include state law claims for negligent failure to prevent sexual harassment and negligent hiring, retention, and supervision.
Okay.
Yeah, plaintiff's counsel isn't just relying on Title VII vicarious liability here. They're arguing that CNM, as an entity, breached its fundamental duty of care.
What's the evidentiary hurdle for negligent retention in a case like this? How do you prove that?
You have to prove that the employer knew, or in the exercise of ordinary care should have known, of the employee's dangerous propensities, and yet retained them in a position where they could harm others.
So they either knew he was a croup or they should have known.
Basically, yes. The implication in the filings is that Daniels' behavior was so brazen, so unrestrained, that it could not have existed in a vacuum.
A VP doesn't act with that level of impunity unless the culture implicitly permits it.
Right, or unless previous complaints were just buried. If discovery revealed any prior whispers, rumors, or reports about Daniels that the company ignored, their liability for negligent retention crystallizes perfectly.
And remember that recording device from her aunt. It was in her tactical vest the entire time. It captured the audio of the assault in that empty building.
The indisputable proof.
Exactly. And here is the detail that transforms this entire case. Sometime after giving Bryant the recorder, her aunt passed away. Yeah. That physical tape wasn't just forensic evidence anymore. It contained the only remaining audio of her deceased aunt's voice on the other side of the cassette.
That is just, it elevates the tape from a piece of discoverable evidence into an irreplaceable chattel, an artifact of immense emotional weight.
And the defense's catastrophic mishandling of that object becomes the gravitational center of the entire punitive damages phase later on.
Because armed with this indisputable audio proof, Bryant finally gets the chance to come forward.
But instead of protection, she steps right into a trap. Let's get into the timeline of the whistleblowing, because this is where the company moves from negligence into active, malicious retaliation.
The pivot from bad culture to active cover-up.
March 31st, 2023. Over a year after the assault, Bryant is working a 1:30 a.m. shift at a GXO Tesla worksite. Charles Reedy, the chief operating officer of CNM, shows up.
At 1:30 in the morning.
Yep. Unprompted, Reedy tells Bryant that Daniels has been let go for stealing, and he actively mentions that he had heard rumors about Daniels sexually harassing people.
Which is an astonishing admission from a COO.
It really is.
I mean, he is verbally confirming that the company had notice of Daniels' predatory behavior. He's validating the negligent retention claim right out of the gate.
It's the opening Bryant has been waiting for. She tells Reedy she was sexually assaulted by Daniels. She goes to her car, retrieves the recording device, and hands it over to the COO.
She just hands him the original.
She gives him the device, the headphones, and the tape inside, explaining exactly what is on it. Reedy asks to keep it so he can listen, takes possession of the physical tape, and promises to return it quickly.
Okay, taking original physical evidence from a victim who is reporting a severe sexual assault is an incomprehensible risk from a risk management perspective.
Right, like HR 101.
Even a first-year HR coordinator knows you never break the chain of custody of a complainant's original evidence.
Yeah.
You make a copy or you advise them to retain it for the investigation.
But he takes it.
Taking possession of it creates an immediate bailment. That's a legal duty to safeguard and return that property.
A duty he obliterates almost immediately, because the paper trail here is brutal. At 4:13 p.m. that exact same day, Bryant texts Reedy asking when she can get the device back, explicitly stating that her deceased aunt's voice is on the tape.
And he replies.
Reedy ignores her, he ghosts her, and then the classic mechanics of constructive discharge begin.
We see the precise retaliatory playbook unfold in these text logs over the next few days.
Let me just track the fallout here. April 2nd, she calls him. He deflects, says he's working on the schedule. They assign her a new site in Decatur.
Shifting her around.
April 3rd, Vice President Michelle Hudley gives her another work site, but right after her shift, Reedy texts her, "Do not report there. That post was already filled."
So they're pulling the rug out from under her?
Bryant asks if she is fired. She begs for the tape back. Complete silence.
Wow.
April 5th, she texts Reedy again. "I have asked for the tape recorder back for several days now. I gave you the entire tape recorder, earphones, as well as the tape inside in good faith. It is all my family has left of my aunt talking."
And again, silence.
Silence. April 7th. "When are you going to give me the tape recorder back? It doesn't belong to you." Silence. By April 11th, the VP just texts her, "We don't have anything open at this moment." She is effectively terminated.
This is textbook retaliatory termination under Title VII.
Just a total freeze out.
Exactly. She engaged in protected activity, which is reporting the assault, and within 2 weeks, she suffered a materially adverse employment action. The temporal proximity alone establishes a prima facie case of retaliation.
But the plaintiff's counsel did something incredibly smart here, right? They didn't just file federal retaliation claims for firing a whistleblower.
No, they utilized state torts to break the statutory limitations of federal law.
This is a crucial point. Explain how the state torts for stealing the tape changed the financial exposure for the defendants, because this isn't just a Title VII claim anymore.
Right. Under Title VII of the Civil Rights Act, compensatory and punitive damages are subject to strict statutory caps based on the size of the employer.
So there's a limit to how much a jury can award.
Exactly. Depending on how many employees CNM had, the maximum combined damages they could face for the federal claims might be capped at anywhere from $50,000 to $300,000.
That's a hard ceiling.
It is. Yeah. But state torts like conversion, trespass to chattel, and intentional infliction of emotional distress, or IIED, do not have those federal caps.
Wait, they took a recording device that belonged to her dead aunt and just kept it? That goes way beyond a bad HR policy. That feels like emotional warfare.
It absolutely is.
It's not just conversion of property, it's holding her family memory hostage. By doing that, Reedy handed the plaintiff a weapon to bypass the federal damage limits entirely.
He really did. Conversion under Georgia law occurs when someone wrongfully and intentionally retains another's property, depriving them of its use.
Even if he took it legally at first.
Yes. Reedy took lawful possession initially, but his refusal to return it upon demand constitutes conversion.
And trespass to chattel.
That's the intentional interference with the right of possession. By attaching the extreme emotional weight of the deceased aunt's voice to these property torts, plaintiff's counsel perfectly primed an IIED claim.
The intentional infliction of emotional distress.
Right. They argued that stealing a family heirloom to cover up a sexual assault is conduct so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency.
And IIED claims don't have those caps.
No. They can carry massive, uncapped punitive damages.
And how did the defense attorney, Caleb Abraham, respond to these specific text messages and the retention of the tape in their February 2025 answer? I mean, she has the texts.
They responded with a wall of blanket denials.
Really?
Yeah. They responded to the specific numbered paragraphs containing the text message transcripts with single-sentence dismissals. Just denied.
Yeah.
They demanded the complaint be dismissed entirely. With prejudice.
It's a bold strategy when the plaintiff has the receipts of the text messages directly proving the demands for the tape's return. Like, we can read them right here.
Very bold. But it gets even crazier when you look at what the executives were doing behind the scenes.
Right, because you're the COO. You have the tape, you fired the whistleblower, and now she has hired a lawyer and filed a formal charge with the Equal Employment Opportunity Commission, the EEOC. The feds are investigating.
So what is your next move?
If you are a COO acting in good faith, you cooperate. You preserve evidence. But Reedy decides to try a legal disappearing act.
Which introduces the corporate shell game, a maneuver that routinely infuriates federal judges and juries alike.
The timeline of evasion here is just a masterclass in what not to do. Let's lay out the chronological paper trail of this corporate restructuring.
Let's do it.
April 2023, Bryant files her EEOC charge. September 2023, CNM files their formal position statement with the EEOC defending their actions. So they are actively engaging with the federal investigation.
Acting like everything is business as usual.
But the very next month, October 2023, Reedy goes to the Georgia Secretary of State and files a name reservation for a brand new entity, Global Security Management Team, or GSM.
He sees the writing on the wall. He's prepping the lifeboat while simultaneously telling the EEOC the current ship is totally fine and definitely not sinking.
November 2023, the Articles of Organization for GSM are officially filed. Reedy is listed as the registered agent and organizer operating out of a new address in Marietta, Georgia.
Setting up shop under a new name.
Fast forward to April 2024. The EEOC informs CNM and the newly formed GSM that a for-cause finding is coming.
Okay, a for-cause finding is the inflection point in these cases. Yeah. It means the federal agency has investigated, reviewed the position statements, interviewed witnesses, and found reasonable cause to believe discrimination and retaliation actually occurred.
It's bad news for the company.
It essentially greenlights the federal lawsuit.
And literally days after getting that news, on April 16, 2024, Reedy officially terminates CNM Defense Group with the Secretary of State. He shuts the investigated company down.
Just packs it up.
And later that month, CNM's counsel actually tries to tell the plaintiff's lawyer that CNM began winding down because it lost a big contract, claiming this all happened before anything was filed.
That narrative falls apart under the slightest scrutiny. You cannot outrun federal liability by simply filing articles of dissolution and hanging a new shingle in Marietta.
So what does this all mean? In their answer, the defense claimed they were operating in good faith, but the timeline tells a totally different story.
Completely different.
They were literally packing the company into cardboard boxes and moving it to a new LLC the exact moment the federal government started breathing down their necks.
This brings us to the doctrine of successor liability. The courts have built robust mechanisms to pierce this exact type of corporate veil.
How does a plaintiff actually prove that GSM isn't a brand new company, but just CNM wearing a fake mustache? What are the evidentiary hurdles?
In employment discrimination cases, federal courts often use what's called the Macmillan factors, or a substantial continuity test, to determine successor liability.
So they look for similarities.
Exactly.
Yeah.
The plaintiff's counsel will use discovery to look for specific overlaps. Did GSM use the same facilities or equipment? Did they retain the same supervisory personnel, in this case, Charles Reedy?
Right.
Did they employ substantially the same workforce? Did they provide the exact same security services to the same client base?
So if counsel subpoenas the payroll records and client invoices for GS, and they look nearly identical to CNM's records from the prior year, the court will just collapse the two entities together.
Exactly. If there is substantial continuity of operations, GSM becomes a successor in interest. The liabilities of CNM flow directly into the new LLC. The legal fiction of corporate personhood does not protect you from fraud or evasion.
You can't just wash your hands of a pending lawsuit because you changed the name on the door.
No, you can't.
Wow.
And tactically, when a jury sees a defendant attempting to pull a fast one with LLC filings while simultaneously holding onto a stolen tape recording, any remaining shred of credibility the defense had just evaporates.
Which brings us to the reckoning, the climax of all this. All the maneuvering, all the denials, the 24 affirmative defenses, it all eventually has to face a jury of your peers. And in January 2026, the jury finally spoke.
And the numbers the jury delivered are a surgical strike against the defendant's entire operational model.
Let's walk through these astonishing numbers. Let's dissect the Phase 1 compensatory damages form from January 14th, 2026. This is about making the victim whole.
Right, compensating her for what she lost and suffered.
For negligence, the failure to prevent the harassment and battery, and the negligent retention of Daniels, the jury awarded $472,800.
Yeah.
For Title VII hostile work environment, compensating her for the trauma of the harassment itself, $234,240.
Right.
For Title VII, damages for termination, the retaliation, $302,605.
So we are over $1 million just in compensatory damages for the workplace violations alone. They are signaling that they fully believe the severity of the assault and the viciousness of the retaliation.
But the state torts are where the jury really unleashes. For intentional infliction of emotional distress, they awarded $560,877.
Over $500,000.
And for conversion, the literal taking of the tape, they awarded $10,000. Now, $10,000 for a plastic cassette recorder seems like a lot, but the real weight is in that IIED number, isn't it?
Absolutely. The $10,000 likely covers the perceived monetary replacement value and immediate associated costs of the physical property.
But the IIE.
The $560,000 IIED award is the jury recognizing the intrinsic, irreplaceable value of the deceased aunt's voice. They're compensating Bryant for the profound psychological torment of having that specific heirloom stolen and held hostage by her abuser's boss.
And at the bottom of the Phase 1 form, the jury checked yes for every single category regarding whether punitive damages should be assessed.
Every single one.
Which triggers Phase 2.
Phase 2 is entirely distinct. Punitive damages are not about making the plaintiff whole. They're strictly designed to punish the wrongdoer for malicious or willfully wanton conduct.
And to serve as a glaring deterrent to any other employer who might consider similar behavior.
Exactly. To send a message.
And the Phase 2 numbers are staggering. The jury hit the corporate entities, CNM and GSM, with an additional $1 million for negligence.
A flat million.
They added $100,000 for the hostile work environment and $100,000 for retaliation.
They are heavily punishing the corporate culture that allowed the assault to happen in the first place.
But then they make it incredibly personal. For intentional infliction of emotional distress, the jury assessed $1 million against the companies. And D, they assessed an additional $1 million specifically against Charles Reedy, the COO, personally.
They pierced the corporate veil on the individual liability.
Right.
They didn't just hold the LLC responsible. They held the man who physically took the tape and orchestrated the cover-up personally liable for $1 million.
And the final line item on the punitive form, the punishment for conversion, for stealing the tape. The jury hit the companies for $10,000. But for Charles Reedy personally, a staggering $750,000.
That number.
I'm looking at that specific number, and it feels incredibly precise. $750,000 in punishment for a piece of plastic and tape.
It is the most telling figure on the entire document, I think.
The jury clearly understood the emotional weight of taking a deceased relative's voice. That wasn't just property theft, that was cruelty, and they made him pay for it.
It's a textbook example of a jury using their financial power to express profound moral outrage. They looked at a COO who thought he could outsmart a misclassified security guard, who thought he could pocket her most precious evidence and just dissolve his company to escape consequence. And they dropped the hammer on his personal finances.
And the final bill just arrived to bring us right up to the present day. Just days ago, on March 19th, 2026, Magistrate Judge Anna W. Howard issued the final judgment for attorney's fees and costs.
The cherry on top.
The court ordered CNM, GSM, and Charles Reedy to pay $491,767 in attorney's fees and $10,899.69 in costs. And that's held jointly and severally.
Meaning the plaintiff's counsel can pursue collection of that nearly $500,000 from any combination of the defendants.
So even if the companies are broke.
Right. If the LLCs are functionally bankrupt or dissolved, Reedy remains entirely on the hook for the full amount of the fees personally.
Wow.
It ensures that the immense cost of litigating a complex, multi-year federal civil rights case doesn't erode the victim's judgment, but falls squarely on the perpetrators who forced the litigation in the first place through their refusal to return the property and address the assault.
So as we pull all these threads together and synthesize the takeaways here, the legal architecture of this case is just fascinating.
It is a masterclass in why documentation matters.
The plaintiff's counsel brilliantly navigated around the Title VII caps by leaning heavily on those state torts conversion and IAE, leveraging the emotional weight of a stolen family heirloom to expose the defendants to multi-million-dollar punitive judgments.
And it perfectly illustrates why the doctrine of successor liability exists, to prevent exactly this kind of corporate shell game. It serves as a stark warning to employers relying on the independent contractor fiction to enforce compliance and dodge basic labor protections.
Right, because the label is often just a legal fiction masking vulnerability.
When that unchecked power leads to inevitable abuse, the legal system, even though it can be slow, has the tools to completely dismantle the corporate structures protecting the abusers.
And while the defense denied everything, attempting to brush off the claims with procedural defenses, the paper trail and the undeniable emotional truth of the evidence ultimately resonated with the jury in a historic way. Which leaves me with a final lingering thought.
Yeah.
Think about that tape recorder. If CNM had simply handed back that recording device on April 1st when Makita Bryant first asked for it, if they had acknowledged her aunt's voice was on it and returned it, the federal retaliation claims might still exist, but would the jury have felt the same level of visceral, righteous anger?
It is highly unlikely the punitive damages would have escalated into the millions without the emotional cruelty of the conversion claim.
Right. Sometimes it's not just the initial crime that destroys a company. It's the profound lack of humanity in the cover-up. It's the arrogance of believing you can hold someone's family memory hostage without consequence.
The case ultimately reminds us that while the law deals in statutes and spreadsheets, juries deal in human realities.
So I leave you listening with this to mull over or explore on your own. What physical objects in your own life hold that kind of irreplaceable emotional power? And what would you do if someone used them against you?
It's a heavy question.
It is. Thank you so much for joining us on this deep dive. Stay curious, keep questioning the structures around you, and we will catch you next time.
Hey, it's Mark, and thank you for listening to this episode of the Employee Survival Guide. If you'd like to be interviewed for our podcast and share your story about what you're going through at work, and do so anonymously, please send me an email at mcarey@capclaw.com. And also, if you like this podcast episode and others like it, please leave us a review. It really does help others find this podcast. So leave a review on Apple or Spotify or wherever you listen to this podcast. Thank you very much, and glad to be of service to you.